Soderstrom. I'm a senior editor here at the Capitol Forum, and I'm moderating, as you can see, our opening panel on litigating and legislating against algorithmic collusion. We have a great group of panelists today. I will introduce them briefly. First, closest to me, Keith Wearer is a managing director at Secretariat Economics, where he's testified at deposition and trial on mergers and monopolization claims, amongst other matters. Keith has worked on some of the highest profile U.S. antitrust litigation in recent years, including U.S. v. Assa Abloy, State of New York et al. V. T-Mobile, FTC v. Qualcomm, and U.S. v. AT&T Time Warner. Next, we have Katie Van Dyke, who's a senior legal fellow at the American Economic Liberties Project, as well as the founder of KVD Strategies PLLC. Prior to that, she served as an attorney advisor in the Office of Policy Planning at the Federal Trade Commission, where, amongst other things, she led the Commission's amicus program. Next, Ken Rakowski is a partner at Holland & Knight. Ken is a first-year antitrust trial lawyer and serves as lead counsel in cutting-edge antitrust matters. Of note, Ken has developed significant experience in defending clients against the antitrust theory of liability, alleging price fixing by algorithm, certainly relevant to today. Finally, James Keep is a partner at Boies Schiller, trial lawyer with extensive experience in sports, big tech, mergers, and antitrust. He's handled high-profile cases including class actions, alleged price fixing, monopolization, and more. James is also the director of the Fordham Competition Law Institute, and for those of you who were up in Fordham a couple weeks ago, you have him to thank, assuming you enjoyed the conference. You have James to thank.
I'm just glad it's over.
You don't. In any event,
it went well. Yeah.
Let's jump right in. Keith, I'll ask you to kick things off. Before we get into this question of when algorithmic collusion might be a Sherman Act Section 1 violation, what's the underlying market dynamic here? How is the tech? How are the mechanisms firms are using to set pricing different than they were 5 years ago, 10 years ago, to the point that this has become such a hot topic in antitrust circles? Could you kind of walk us through what you're seeing there?
Yeah, sure. I'd like to just start by thanking Capitol Forum for inviting me to speak on this important topic, and I'll return the favor by giving you guys a plug. I always find your guys' content to be among the best reporting on antitrust issues. I also just want to say, so at antitrust economics conferences these days, you're required to give disclosure. And so I will just say that I am not working on any of the algorithmic collusion cases, and I'm not aware of any position taken by my firm on those issues. So this question of technology, and I will just be brief. I think everybody's aware of ChatGPT and LLMs. They make use of a technology that's deep learning and machine learning technology that is something that has come about in the last 5 or 10 years, and it's really created a revolution in what I would say is the ability to make predictions. And LLMs are all about predicting the next token that is going to, and you build a sentence by having these algorithms predict. And there's been a number of people who talk about this as being like an industrial revolution in the technology and ability to make predictions. And I think, my reading of the complaints and other things relating to these algorithmic collusion cases, we're talking about prediction technologies that are being used in these algorithmic pricing models. And so that's something that's new, and that's created economies of scale and the ability to do this kind of pricing recommendations at some scale. And as you probably read, these kinds of models also require a lot of data. And so there are economies of scale in having big companies collect data from a lot of different entities in order to create better predictions. And so that's really at the heart of why we're seeing that now. I think in the past, I was at a panel I was at a conference at Northwestern University a little less than 2 weeks ago where these topics were talked about among economists. And they were really focused on whether or not the information, how the information was being used, and we'll talk about that some more. But I will leave it there, and because we don't have that much time for everybody else.
We have a lot to cover. So James, to draw you in, we're starting to see courts grapple with the questions Keith identified. And up until recently, that had been only at the district court level. In August, we had an opinion from the Ninth Circuit in Gibson v. Sendon. That was the first appeals court to weigh in on questions around alleged algorithmic collusion. Case involved hotel rooms in the Las Vegas Strip. Could you talk a bit about that decision? And in particular, given that it's the first to come from a circuit court, how influential do you see that being on other courts going forward, on other plaintiffs going forward in the algorithmic pricing context?
Sure. I guess I should have the same kind of I'm speaking only in my personal capacity, maybe my academic capacity. I have been on both sides of the V in these issues, as well as when I was at Brattle overseeing economists on both sides of this. So kind of leading up, some context for leading up to Gibson. I like to think of Gibson also as rainmaker because it gives you a little context for the AI part. You know, in the past, there was an old safe haven in information exchanges, for those older ones of us in the crowd, where you had, public information, historical, aggregated. It was more like an informational benchmark. And then with AI and third-party algorithm and pricing, essentially, firms, it invited this hub and spoke world, and you see it with Interstate Circuit and Interstate Circuit, which is the basis for Yardi, and we'll get to RealPage. And then the question really is, well, is there going to be a safe haven, essentially, on the defendant side? And if you read the district court in Gibson as well as the Ninth Circuit, and I know there was just an en banc filing made the other day that I read as well, I mean, it certainly is, under certain conditions, going to be where everybody goes for the safe haven. But it's more probably going to be in the advice for what you need to do to be in that safe haven. And so there, the court essentially, well, let's just say there were five casino hotels that used this service, Rainmaker, which is what you could view it. You could view it innocently as a price recommendation service, or cynically, as a third-party, hub for getting prices up. And what the district court and the Ninth Circuit essentially found, which is somewhat startling, is that there was, there's no restraint in the market. They essentially said these were ordinary sales contracts providing a service, which is a recommended price, no different than lawyers and other service providers. They said they weren't really vertical restraints because there was no restraint in the chain of distribution in the market. They didn't see horizontal restraints, which you see in some of these other cases, but you can get to that. And it also involved essentially the sharing or use of public information without any evidence, it appeared, of an agreement to follow the recommendations. And so it's kind of so then they find that there's no reason to even do. There may be an agreement. There's agreements, but they're irrelevant agreements in their view. They were just licensing agreements. There was no agreement horizontally they saw or vertically in the industry, or a causal connection between those licensing agreements and these perceived or even probably demonstrated price effects in the marketplace. And so they say you never get to the rule of reason and you have the wrong kind of agreement. So this is the new safe haven, but it has certain conditions. They gave up, by the way, I think the parties gave up the hub and spoke theory in the middle of the case. It kind of highlights that you're in a dilemma, I think, as a plaintiff, where you don't have a lot of information to plead, that puts you into these other theories. In Yardi, you will hear about, there's a lot of information. Come together, let's raise prices, in the invitation context. And so I think you're going to see, everybody trying to construct on the defense side their service, a third-party service around the Gibson case, and try to do that quite carefully. I do, and I think it will have influence on courts where those facts exist, but at the same time, I think it'll be fairly easy, not easy. There'll be many situations where you're going to find facts that take it right out of Gibson, because there's essentially a predicate for an invitation to do things together. There's going to be evidence that we all need to do this to make it work, what you see in RealPage. And so it's there, and it wouldn't surprise me if it stays there, and will be how people design their programs around it.
Yeah, absolutely. And Katie, to draw you in, so Gibson certainly is not the only case where plaintiffs have failed at the pleading stage. But we have had a couple district court decisions, and Yardy is one of them. James mentioned in the algorithmic collusion context where plaintiffs have fared better. Again, Yardy and RealPage in the Middle District of Tennessee. Could you talk a bit about those cases and why those were able to survive motions to dismiss?
Sure, thanks. And I don't have any disclosures to make. I was a litigator for a long time, but I'm very much in the policy world now. So I think before I can say what's different, I think it's important to think about what the commonalities are in these cases. So, and to sort of clarify what they are, Gibson v. Sinden involves a pricing algorithm, an algorithmic pricing tool that was used by, or is used by hotels on the Las Vegas Strip to set rates for rooms. Yardy, which you mentioned, is another algorithmic pricing tool to set rates for rental properties for multifamily housing units. RealPage is the same thing. And then you also have a fourth case that's currently pending in the Third Circuit, Cornish versus Caesars, which involves the same tool that was at issue in Gibson v. Sinden, and is used by casinos in Atlantic City. So all of these cases involve competitors using the same pricing tool. They're not just, they do make predictions, but they use those predictions to set prices that maximize profits for the users. So all of them involve competitors using that same pricing tool. They all involve competitors sharing their sensitive and granular pricing and occupancy data with the pricing tool. They all involve competitors delegating pricing strategy to these systems that are automated and require manual override and special permissions to reject the recommended price. They all involve competitors largely widely accepting the pricing recommendations. They all involve markets where, after the pricing tool was adopted by the competitors, pricing went up regardless of occupancy rates. And they all involve, until the plaintiffs dropped their horizontal claim on reply in Gibson v. Sinden, they all involve allegations of tacit horizontal agreements, meaning that these aren't cases where all of the competitors necessarily got together and said, hey, we're all going to use this tool, right? Great. It involves these allegations that all of the competitors understood that the other one would be providing the information and using it. And so that's the sort of concerted action we're talking about. So what's different in these cases, and the allegations that the courts have been looking at only at the motion to dismiss stage at this point, is really more about distinctions of degree rather than kind. We're looking at how was they all shared the sensitive data. How was it used? Was it all pulled together? In Sinden, in Gibson v. Sinden, there are a lot of, and in Cornish versus Caesars, it's a little unclear exactly how the competitive information was used once it was shared. In RealPage, there were more serious allegations of peripheral conduct. For instance, like RealPage was involved in daily monitoring and conversations between the property managers and RealPage employees. They facilitated some sort of like direct collusion or engagement between the competitors. In Yardy, there were clearer allegations of commingling of the data and clearer allegations about, I think, promises of everybody using it. But really, these are really like more about shades of gray. And so when I think about the differences in these cases, I think what we're really frankly talking about is differences in how the judges viewed the allegations. And we're talking about, what are the pleading standards that allowed the judges to make these decisions and almost engage in judicial fact-finding. In Gibson v. Sinden, the judge gave a lot more weight to the fact that sometimes, yes, hotels did reject recommendations and said this isn't mandatory, and they didn't all adopt it at the exact same time. Whereas in Yardy and RealPage, the judges gave significant weight to the fact that the pricing recommendations were largely accepted, and also gave significant weight to the fact that it would be, illogical for these companies to pay for software that they don't intend to use. So I think we're really talking about what are the pleading standards and how are judges supposed to evaluate them? Because in one case, in Yardy and RealPage, you have judges who, in my opinion, did what they were supposed to do and accepted those allegations as true. And in Gibson v. Sinden and Cornish versus Caesars, you really had judges kind of weighing the evidence and engaging in judicial fact-finding.
Right. I hear you on that. I think, Ken, to draw you in, and Katie alluded to some of this, as did James, one area where we've seen plaintiffs and courts take slightly different approaches is on the question of whether these alleged algorithmic pricing conspiracies are horizontal in nature, whether they're vertical in nature, in the case of Gibson, whether they're neither. Certainly has important implications, obviously. Is this per se? Is this rule of reason? How should we be thinking about these? Could you just talk about that idea more broadly, how plaintiffs have pleaded these allegations and how courts have generally approached these questions?
Yeah, sure. And I'll just give my disclaimer. My views are my own, not those of Holland & Knight or Holland & Knight's clients. Happy to be here. Thanks for having me. So all of these cases, the algorithmic collusion cases that we're talking about, are all what in antitrust circles are sort of classic hub and spoke theories. So I like to think of a bicycle wheel, right? You have the tire, all of the competitors around the rim, and then you have the software in the center of the bicycle wheel, the RealPage, the Yardy, et cetera, and spokes going out to each of the different competitors. And so traditionally, hub and spoke conspiracies have both vertical and horizontal components to them. Section 1 obviously requires an agreement. So typically there would be an agreement among the competitors on the rim, and then there would be vertical agreements from each individual competitor down to the software and back. And so for an information exchange, this information goes in and comes back out. In these cases, though, have been called, I think in many of the cases, essentially a rimless hub and spoke conspiracy, right? So you can either prove an agreement under Section 1 by direct evidence or circumstantial evidence. All of these algorithmic cases, there's absolutely no direct evidence, right? There's no competitors talking to competitors. We're going to use RealPage, you use RealPage, let's fix prices. That's the traditional hub and spoke conspiracy, is there's some interaction between the competitors on the rim. Here, there's absolutely none of that. It's just bilateral communications between each competitor individually with the software company. So all of these cases, really the game is about alleging enough facts, and if they get further beyond a motion to dismiss, trying to come up with facts and marshal facts and discovery at summary judgment to prove a tacit or implied agreement among the competitors around the rim. The Gibson case stands out on the one hand because there were two claims in the trial court that were dismissed by the District of Nevada. There was the hub and spoke claim, and then there was just a purely vertical claim. Plaintiffs, in the course of briefing that, abandoned the hub and spoke claim, and all that went to the Ninth Circuit and came out in the opinion was the vertical claim. And so you could read that opinion, and the court essentially said, these are just software licensing agreements. They may not even really be vertical agreements because it's not a distribution chain, right? The software company is not providing rooms that the competitor hotels are selling. It's really just software as service. So it might not even be correct to call them a vertical agreement. But anyway, at the end of the day, they're unilateral, and it's just a software licensing agreement, and there can absolutely be no Section 1 liability. So I think the notion that there's going to be purely vertical claims in these cases going forward is dead after the Ninth Circuit Gibson opinion. That said, on the per se rule of reason, right? So traditionally in antitrust law, if an agreement is found to be per se, it lowers the burden of what plaintiffs have to prove. They don't necessarily have to show a geographic market. They don't have to show market power, right? It's much easier for plaintiffs to marshal facts if a case is deemed per se as a matter of law versus rule of reason. So RealPage and Yardy are the only two cases in this space that allowed the claims to proceed past the motion to dismiss. RealPage said this is rule of reason. Yardy said this is per se. Essentially, the difference there is the court in RealPage was, it came after Gibson 1, but before Gibson 2. It was a 76-page opinion that Judge Crenshaw wrote. It was a really deep, hands-on analysis, thoughtful opinion, right? And they said, even though we're saying that plaintiffs have alleged not proven, a potentially tacit or implicit agreement around the rim, this is a new technology, and the evidence really isn't all that great. They skated by on a motion to dismiss, but it's not per se. And essentially then Judge Lasnik in Seattle and Yardy said, I don't have that authority. If I'm going to find that the complaint stated enough factual material to get over the threshold of suggesting there was an implicit or tacit agreement on the rim, I am bound then. Horizontal agreements are treated per se under antitrust law. But the Yardy opinion, much shorter, I think about 18 pages, there's a paragraph at the end that has a caveat that there are clear factual disagreements between plaintiffs and defendants about the facts that are alleged, that are the crux of the issue that get it over the threshold to survive a motion to dismiss, whether those are true or not. So if those aren't true, then plaintiffs might have a problem. So it was essentially a roadmap. But we're now stuck in a world where we have two cases that allow these claims to go forward. One's rule of reason, one is per se, and there's a big difference then in how discovery and summary judgment and ultimate resolution on the merits, should they get there, is going to play out.
Couldn't agree more. So a lot of this discussion has been legal in nature. When do we have an agreement? Is it vertical? Is it horizontal? Keith, from an economics perspective, when competitors are using a common pricing algorithm, what does it look like for that to have an efficiency enhancing or competitively neutral effect versus when might the common use of an algorithm increase the likelihood of tacit collusion, parallelism, otherwise have anti-competitive effects?
Yeah, that's a tough question. Let me give you one answer is that what it's not the use of confidential information. So I would argue, and I think the economists at this Northwestern conference I mentioned earlier all essentially agreed that the use of confidential information would be important for the efficiency arguments and wouldn't be necessary for collusion to occur. Just from an economic perspective, that I'm not talking about legal liability here. So why is that? So what are the efficiency arguments? Markets work when prices adjust to changes in supply and demand conditions. And if prices are not adjusting, you have inefficiencies happening. And I think a lot of the economists at the Northwestern Conference thought that apartment building managers, for example, were not all that great at setting prices. And when you have prices that are not adjusting properly, you can have shortages, you will have excess supply, you'll have people who are not getting apartments when they should be getting apartments, all those kinds of bad things. And I think some of the efficiency arguments that have been made in these cases is we're just helping the market work better by helping the apartment managers to set prices more effectively and have the market clear. These are potentially real efficiencies, whether they're actual, that's a factual question. You're looking very skeptical.
I'm asking whether excess supply would be something that we would view negatively from a consumer perspective. I don't view that as necessarily bad.
So that means that prices are set too high. If you have excess supply,
Fair.
Right, then you've got people who want to get into an apartment, but prices are set too high, and prices should fall in order for demand to equal supply.
Can I ask, empirically, would we expect a common pricing tool to lead to lower prices than lower prices than otherwise prevail? Because my instinct, right,
I mean, so let me first say when it's bad, right? So the question is, from an economic perspective, do these algorithms essentially suggest prices that are individually profit maximizing for each of the owners of the apartment buildings, or are they jointly profit maximizing for the collection of apartments? And really, that's the crux of, at least from an economic perspective, of whether or not these are anti-competitive, completely apart from whatever the legal perspectives are, right? There are a couple papers on this that have been recently published. There's a gasoline paper. It looks at German gasoline stations and really finds evidence that these are potentially anti-competitive. What they found is that profits went up for gas stations when they were in a market that was duopoly or more competitive, and that the use of the algorithm had no effect on margins if it was already monopolized, right? So if these algorithms were helping with efficiency, you would expect there to be an increase in profit both in monopoly and non-monopoly markets, because you're more effectively maximizing your own profit.
They were better at coordinating, but not better at setting prices.
Correct. So that would be that. Then there was another paper that actually looked directly at RealPage and was presented at this conference that basically tested empirically whether or not the pricing was for the users of the algorithms were jointly profit maximizing or individually profit maximizing. And this paper found real evidence, I think pretty convincing empirical evidence, that the algorithms were suggesting prices that were being accepted that were jointly profit maximizing as opposed to individually profit maximizing. Bottom line is, either could occur. There's a couple empirical pieces out there right now. How easy would it be to prove in court if we're in a rule of reason environment? That's a big question.
Yeah. Totally makes sense. Ken, to move us back away from the economics to the legal questions. And I know you discussed this a bit earlier, but fundamentally, in the context we're discussing here, alleged algorithmic price fixing, what kind of evidence are plaintiffs looking for? More concretely, especially given the decisions we have now, what is going to get you past a motion to dismiss? I realize that's an overly broad question, but based on what you see in the cases, how do you think about that question?
No, that's a great question. I think both the Vegas and the AC cases, had a line in the motion to dismiss opinions that said, algorithmic collusion or price fixing by algorithm is a new antitrust theory, right? Plaintiffs just, RealPage was really the first time they rolled it out. It's a novel antitrust theory of liability in search of facts to fit it. So that's what we've been grappling with in these early decisions, these motion to dismiss decisions. And you have the two casino cases, which say plaintiffs didn't plead enough facts, and then you have the two multifamily cases, RealPage and Yardy, where the court said you did plead enough facts. But essentially the framework that all four of those courts have used was really the framework that came out of Gibson, right? And so I think the timing here is interesting, because Gibson dismissed the Vegas case initially with an opportunity to replead. Then RealPage came in and distinguished RealPage from the framework that the Gibson court in Gibson 1 had set up. And then Gibson 2 on the amended complaint came back and distinguished the amended complaint on the RealPage framework. But it really all came out of Gibson 1. And it's essentially, I think, three factors right now. Is one, the who, what, when, and where of a conspiracy. When did the conspiracy start, and when did folks join it? And in these cases, the casino cases, one was 10 years in a 14-year period where folks sort of came in to the conspiracy. And so the Gibson case said, there's no parallel conduct here because it's a 14-year time period. Two is information exchange, right? Whether the information that the competitors around the rim gave to the software company that spoke was confidential, non-public pricing and occupancy information, or whether it was publicly available. You could go on websites and find it out. But not only that, not only did it have to be confidential, it had to either be mixed or in a melting pot of combined aggregated information that the algorithm used for pricing recommendations, and or the software had to be a conduit for one competitor to pass their confidential information to another and vice versa. Third in the framework is, did the competitors delegate their independent pricing authority to the software or not? And so that's why you get in all of these complaints, defending competitors accepted the software's recommendations 90% of the time, greater than 90% of the time, around 90% of the time, 80 to 90% of the time. That matters very much, because if the competitors didn't actually delegate their pricing authority and agree to be bound by the recommendations that came back, the conspiracy allegations fail. So that's really the three-part framework, but I think as we've seen these cases progress over time, and we now have DOJ consent settlement agreements with some of the defendants in the DOJ RealPage case that include very detailed definitions of confidential information and what constitutes confidential information that flows or impacts pricing, I think it's really crystallized around that second factor. So can plaintiffs at the motion to dismiss stage come up with enough facts to show that confidential information is passing through the software from one competitor to another, or that it's combined and used aggregately for the algorithm to provide pricing recommendations? And if you can, the two cases that have proceeded have moved on, and if you can't, they've been dismissed at the pleading stage. And just to put a final point on it, I think these algorithmic collusion cases put plaintiffs' antitrust counsel really between a rock and a hard place, right? Because an algorithm, software typically is sort of a black box, right? Unless you know what the coding is and the ones and zeros and how it actually works, it's very difficult to know what it does. So unless plaintiffs have confidential witnesses, like they did in RealPage, they had a lot of confidential witnesses in RealPage, or unless you have documents from a prior government investigation or a whistleblower, plaintiffs are really shooting in the dark as to how the software works. And that runs up against their Rule 11 obligations. And I think that's the dynamic we've seen play out in the Vegas and Atlantic City cases. You know, defendants in their briefing have both accused plaintiffs there of not being able to say that the confidential information crossed the streams or was mixed because they didn't know it and they couldn't. So they danced around, is the phrase they used in the Atlantic City Hotel, danced around saying it without actually saying it. So I think that's something to keep an eye on going forward, is how plaintiffs deal with that, you know, rock and a hard place situation between Rule 11 and not knowing the information about how the software works.
It's a tough spot. James, similar question to you. Ken walked through these kind of three factors, information exchange maybe being the key one. Just from a general defense perspective, in the algorithmic price fixing context, where do you see the weak spots? Let's say a new complaint's filed tomorrow here on the D side of the V. Where do you see the most fruitful lines of attack for defendants, especially in the motion to dismiss context?
Everything Ken said. So it is a little flip side of what Ken said. And I like the same or similar buckets because they're really the three theories that are being pursued. You still have, and by the way, you still have straight up rule of reason cases on information exchange. You know, Todd v. Exxon and Maple Flora, you know, you can go all the way back. And so one thing the defendants will look for, of course, is just that it's public information. And I think that was very influential in Gibson. It's like, okay, it's a more efficient way instead of having somebody go around and look at everything. You know, if it's public information, you know, even I think, frankly, at a granular level, and even used as a vehicle to share that as opposed to delegation, you know, I think plaintiffs have a hard time with that. At the same time, it's probably not that useful for, you know, AI and algorithmic pricing if you're not, essentially what you're trying to do is have a better version of or insight into supply and demand using confidential information that nobody can do by themselves. So in that environment, if you're in a real third party doing something, so you're past information exchange with just public information, I think what you have to, you know, I think it's with Yardy. Yardy was this kind of interesting way of kind of breathing, you know, steroidal life into interstate circuit by saying, oh, no, this is per se because it's your classic invitation to let's all go raise prices. and here's how we're going to do it. The defendants are going to say, or look for that there is no evidence of that type of kind of invitation and response.
Well, I can't help myself. I mean, in Interstate Circuit, there was actually a letter
Yeah, I
from
know.
the company that went out all of them at the same time and said, don't send your films to second-run houses, just send them to first. And they all wrote back and said, yes, we are going to do that. So I think
Well, it wasn't-
factually it's very different.
It wasn't that good, actually. It was just CC'd on the
Okay,
the people. Yeah, it's 1935. I mean, what are you going to do?
So the CC was a literal.
The CC, I mean, it was it's hard to see whether Interstate Circuit under those facts would survive today with just copying the competitors. Because, by the way, a lot of these cases also are folding still into parallel conduct and plus factors. And so a defense is going to also look for, if you're trying to create a rim, okay, the defenses say you can't create a rim on the information exchange. You can't create a rim on the invitation to collude, because you don't have any factual predicates to fit within Yardy or Yardy's version of Interstate Circuit. And the other one, you say you can't create a rim on the delegation of real page. Everybody quotes Maureen Holhausen's, just have Bob do all the pricing, which is really fantastic. And I think a lot of the part of the evidence in real page was the letting everybody know and that the algorithm works best or only works if there's at least 80% or something participation. That's the kind of evidence, additional evidence, the kind of communications that add to plus factors. And so the weaknesses are going to be where you don't have evidence that are the plus factors. Economists can always find something that's against somebody's economic interest. And so that one's,
Is this true, Keith?
you could find an economist, I give you some names of, depending on who you represent, I'm just saying. So, not you, of course, but we all know who you need on this, depending on what side you are. But the point is, I think it's the communications, the design. If the design is kind of neutral, fits into this Gibson. Oh no, we're just recommending things. We're a pricing service. It happens to be sophisticated and useful. It's just what benchmarking used to do, but it does it in a better way. That's where the defendants are going to go, and the plaintiffs are going to be looking for, marketing materials and email. The problem is you can't find it. You have this Rule 11 dilemma, where you're going to have a hard time framing it. You could frame it, but can you find the factual predicates to put in a complaint legitimately is going to be the challenge.
It's clearly challenging. So Katie, like both James and Ken discussed, whether an algorithm has access to non-public, competitively sensitive information, really big question, maybe a dispositive question as far as how courts are thinking about these things, even at the motion to dismiss stage. Could you talk a bit about that, how have courts treated the issue, which I suppose we've covered, and maybe to take it a step further, do you have a view on how courts should be treating that question?
Thanks. I do have a view. James and Ken are great defense lawyers. Y'all are very good at this, and
I'm on both sides.
well,
of this.
you're on both sides. Sorry,
Yeah.
but this is where I was a plaintiff's lawyer for a long time, and it's great to say like, oh, this is a new novel antitrust theory, and it's in search of facts, and plaintiffs are right on the edge of the scary Rule 11 violations, the who, what, when, where of a conspiracy. But when you do look at Interstate Circuit and Saucony Vacuum and like pretty recently American Needle, what the Supreme Court has told us over and over again is that Section 1 is a broad statute. It is not dealing exclusively with an express agreement between conspirators. Section 1 is concerned with what we call concerted action. And what's concerted action? And what the court has told us is we're not concerned with the form of the price-fixing conspiracy. It doesn't have to be, the old all defendants get in a smoke-filled room and exchange prices, or what we saw, or like the auto parts price fixing case where defendants were exchanging emails and allocating customers to each other. We're concerned with the end result. And here, I think what courts really need to think about is this isn't just a software licensing agreement. We're not talking about Microsoft Word or Adobe Acrobat or even QuickBooks. This is software where all of the competitors are handing over highly sensitive information, whether it's confidential or not. It's highly sensitive, occupancy rates, individualized pricing. They're handing this over to a third party with the understanding that it is going to give them back the optimal price for them to maximize their profits. They're using the same tool collectively to set prices, and it is upending, and you'll correct me if I'm wrong on this, traditional ideas of supply and demand, such that regardless of occupancy rates, they can keep their prices high. And the way these work, to be clear, and there are papers about this as well, is that even if you tell when a pricing algorithm's ultimate goal is to maximize profits, it defaults to following suit. If a competitor raises their prices, it's going to raise the other competitors' prices as well. It's not a tool that is used to gain new customers by undercutting. That is not how they work. And so we really have to get back to this basic idea of what is Section 1 about. It is about concerted action that harms competition. And that is what is happening here. You have groups of competitors with market power handing over sensitive information, using a common agent with massive computational power to develop a uniform strategy for setting prices. That is tampering with pricing structures, and that's what Section 1 was designed for. And so I think that is how courts should be looking at it, and not getting it wrapped up in this idea of like, oh, did they all talk to each other? How intense was the marketing? How intense was the marketing material about how many people had to join? There is no other reason to use this tool unless you know that everybody else is using it, because you don't want to keep raising your prices if all your competitors are going to be undercutting you.
We do need to get to legislative options. Does anybody, just because I figure folks might, anybody have a quick response to what Katie said?
So does your view,
And I knew it was
Katie,
going to be Ken.
does your view change if the competitors have in their agreement with the software that their confidential information is only to be used for setting their pricing, and don't use anybody else's confidential information in setting my pricing?
I don't think it does, because you still have this tool. You're handing over your pricing strategy, and you are all using the same tool and the exact same strategies and the exact same levers. You're not even doing it. A computer is doing it, and you're abdicating all authority over your pricing strategy to a single common actor.
Yeah, I would just
using the same formula.
Yeah, I would say you can't. I don't think you could presume if that's delegation inherent in the design, and therefore it's automatically essentially a rim under a hub and spoke. I mean, that would be essentially saying maybe that is for legislation if you're going to essentially outlaw that service, because what you're saying is it's only useful for profit maximizing, and it's going to, so it necessarily is anti-competitive. And if that's the case, irrespective of the case law, then it seems to me it's a legislative issue. I would say, with what Ken said before, that it's a lot easier, actually, circumstantially, to find that rim, whether it's through an interstate circuit kind of approach or a real page approach, that, the evidence is out there to find. And some of it, I mean, obviously in interstate circuit, I mean, in Yardy, it was right in the materials. This is what we're all doing. Let's all do it together. And so, obviously, these third-party providers are going to learn, without AI, without machine learning, not to do those kinds of things or say those kinds of things. And so that's where I think the fight is going to be.
And I think it's right to say there's a lot to learn. And like the Rule 11 comment does, it gets to me a little because I don't think it's appropriate to say that plaintiffs can't succeed on a case because it's hidden behind a black box that they can't get to unless they get the documents. That's why we used to have pleading standards prior to 2007, not that long ago, that allowed plaintiffs to go forward unless there was no set of facts under which they could prevail. And so here we're talking about there's some pretty suspicious public behavior going on here, and markets are flipped, and competition is clearly impaired by these like ever rising prices regardless of occupancy. But sorry, you can't go forward with your lawsuit because you don't know what's inside our black box, I think is a really onerous standard to put on plaintiffs.
And just to be clear, I wasn't impugning the credibility of any of these plaintiffs' lawyers and saying that they had.
I know.
I just think that the way that Gibson and Cornish have sort of articulated the standard, Cornish in particular, says it's not enough just to say in your pleading that every competitor is giving their own confidential information to the software. They got to say what's going on with it. So to me, that poses a problem.
But
Yeah,
that's
the evidence is
impossible
beyond
to
the
do
black
unless
box,
they get
yeah.
discovery.
Maybe I can just, I find troubling the focus on confidential information sharing. Simply because, I mean, there's been so many cartels out there where people get together and they have agreements. They're not sharing information with each other necessarily. They're just saying, hey, let's all increase our prices. It is not a necessary element for algorithmic collusion, people collusion. And if the case law is going to be that way, then maybe we should segue to the legislative fix.
Let's segue.
And because,
Yes.
then we need something different. And let me just say, among the economists at this conference I've mentioned a few times, everybody was in agreement that if we were going to have an algorithm that was helping people efficiently set prices and not jointly collude, you would want that algorithm to have more information. And it did, and the sharing of confidential information wouldn't necessarily be a bad thing. And as I said before, it's not a necessary element for anti-competitive outcomes. So if that's where the courts are going, legislation is
Can I ask
probably.
one question for you, though? How do you, as an economist, distinguish between the joint profit maximizing function and the unilateral function?
So this paper that I mentioned by these two UPenn economists really did an ingenious kind of empirical study to try to look to see, it has to do with the statistical link between price movements between the two firms. Is there evidence of price cutting, prices moving, down when someone's moving up in order to try, if you have more, more apartments that are available in your building. I think that paper is worth looking at. It is not an easy problem, which gets us to the legislation problem, right? Because, if we're in a real rule of reason world, we can't interrogate the parameters of not a large language model, but an AI model, right? I mean, these parameters are just, you can't look under the hood of these models and try to understand, are they anti-competitive? Are they jointly profit maximizing, or are they individually profit maximizing? And so really the question for legislation is, can we do away with the possibility of bad outcomes while retaining some of the efficiencies? Maybe that's not going to be possible. I don't know.
It's a tremendous segue. We've given very short shrift to legislative options, but we're going to do it anyway. It's going to be quick. Katie, I know AELP has testified in favor of AB 325 out in California. Could you just talk at a very high level what kind of state and or local laws, or as I learned today, ordinances, do you think might be valuable here as far as addressing?
Sure. Lee Hefner at AALP testified in favor of AB 325. That law, which was passed but hasn't actually been signed and hasn't actually gone into effect yet, prohibits pricing algorithms where users are coercing others to use the recommended price. And so I think when you think about what that's getting at, it's really aimed at preventing anti-competitive uses like Amazon, for instance, Amazon requiring retailers to use its pricing tool if they want to be in the buy box. And so we're talking about preserving really intra-platform competition, preserving competition between the retailers who are using the tool, and not so much worried about like how the different platforms are competing with each other, but what's going on with the retailers who are using the platform. You've also seen laws passed in localities like New York, I believe, I hope I'm getting this right, that that really do ban the use of pricing algorithms for in the rental market. And I think what these are actually getting back to the basics of like what was Section 1 originally designed for. And it's designed to promote competition and prevent this sort of collusive or concerted behavior that destroys competition between competitors.
And then Keith, last but not least, very quickly, any thoughts on what legislation, to the extent it's enacted, should do, shouldn't do, anywhere to stay away from, anywhere you think is more fruitful?
So I'm not going to make a specific recommendation, but I will say that we're at the tip of the spear of all this stuff. Right.
Too early,
I mean,
yeah.
if we're gonna legislate here, we need something that is somewhat flexible and can handle new developments. And I'm not sure I'm the right person to make that kind of recommendation.
I'll just say one
James,
thing. I
I'm
mean,
gonna let you-
typically for legislation, it's a result of market failures, and you see this in Europe and elsewhere where they're with AI. They're legislating, and the market is still developing. It's you don't understand what's going on, and certainly there's a lot of competition at all levels of the marketplace, but they're out there legislating without a market failure. So, I think the antitrust laws, either side of the V, there's only a couple opinions out there. There's a lot to play out. I know certainly there is a view that they should just be anti-competitive on their face, just for how they are designed, and that could be legislation. But I think fighting it out in the common law of antitrust is a good way to go for at least the next several years.
I mean, one thing you could think about is limit the share that any one algorithmic firm has in a particular market in terms of who the recommending prices are. That doesn't solve all the problems, and it doesn't solve the problem that we haven't been talking about, which is algorithms colluding with each other.
Sure.
That's for another panel. I think with that, Jake, are we wrapping up?
Yeah, fantastic. We'll take a 3-minute break and go right into panel.
Thank you, everybody.
Thank you.
All right, thank you.
Thank you.